The following program was produced by the United States Courts.
Welcome to On Topic, where we talk about the programs and issues, events, and people shaping the federal judiciary. I'm Karen Redmond with the U.S. Courts. Today we're talking about the Federal Probation and Pretrial Services Program with Judge Irene Keeley, Chair of the Judicial Conference Criminal Law Committee. Welcome, Judge Keeley. Judge Keeley, last fiscal year, budget cutbacks and sequestration hit probation and pretrial services offices hard. In the current fiscal year, FY 2014, what's the funding status?
Well, Karen, it's actually better. Probation offices are in a position now to, instead of batten down the hatches and shrink staff, they're able to hire staff to bring in new trainees for probation offices and to increase the support staff in the offices. We're very happy about that because, of course, the caseload for the probation offices is the highest it's ever been, and without the ability to bring on new probation officers, we were facing a terrible crisis. So I won't say that there isn't going to be a crisis again in the future, but right now the circumstances are much better than we could have even hoped 2 years ago.
Evidence-based practices are a cornerstone of the federal supervision program with a goal of reducing recidivism. Do evidence-based practices help federal probation officers predict who will reoffend?
The evidence-based practices that are being used in probation allow the probation officer to weigh the risks for the offenders, to identify those offenders who are at higher risk of recidivating versus those who are at lower risk and may never recidivate, and thereby put scarce resources toward the supervision of the higher risk offenders.
Judge Keeley, Attorney General Eric Holder has said that too many Americans go to too many prisons for far too long. Solutions to this problem include focusing resources on the more serious cases and releasing offenders early. What would a shift like this in DOJ policy mean for the federal probation system?
Our committee, the Criminal Law Committee, has been looking intently at this issue because the offender has to go somewhere. So if there's a shift in DOJ policy, it's most likely going to be into the community where probation officers are going to have to supervise offenders at greater numbers and at earlier intervals than would have been planned at the time of the sentencing of the offender. This is a shift in costs. If it's coming out of the BOP and the Department of Justice, that means it's coming onto the shoulders of the judiciary, particularly in probation and pretrial services offices. So we're looking very intently at what is being proposed both in Congress and at the Department of Justice to determine what kind of needs we are going to have that will have to be met by budget adjustments, and to make sure that we're firmly on top of that and avoiding any crisis in funding.
In July, you testified before a task force of the House Judiciary Committee that's looking into the problem of over-criminalization in the federal system. What chief concerns did you communicate to the task force?
The chief concerns that I communicated to the task force were three. First, the judiciary shares the concern of the task force and all other affected agencies about the over-criminalization of federal law. Second, I communicated that the judiciary's longstanding policy opposing mandatory minimums remains firm, and that we strongly support the provisions of the Smart on Sentencing Act that repeal mandatory minimum sentences either in whole or in part. And finally, I communicated to the task force that we strongly support the Sentencing Commission's decision to amend the drug guidelines. In saying that, however, I did advise them that we had very serious concerns about the implementation of retroactivity because of the very real risk of crisis it would present to the probation and pretrial services offices and the courts.
Generally, there appears to be interest in Congress in alternatives to incarceration as a means to reaching sentencing goals. But some of those alternatives have the judiciary concerned. Why?
Money. Plain and simple. Any alternatives to the current method and means and rate of incarceration are going to affect probation officers' ability to effectively supervise these offenders when they return to the community. And let me emphasize, money relates to risk of safety in the community. We're not looking for staff just for the sake of staff. If we do not have the funds available to hire up with the probation officers to staff this kind of a challenge, then the risk to the community will increase because the level of supervision that will be required and should be available will not be.
Thank you, Judge Keeley, for talking with us. And thank you for joining us. I'm Karen Redmond with the U.S. Courts, and that's On Topic. Join us next time.